Good morning. Are you Angela Reyes?
Yes, ma'am.
And this is cause numbers 26 DCCR 0265, 0787, and 0788. Ms. Reyes was previously in court, entered pleas of guilty in those three cases. And I've received the pre-sentence report. Have you both had an opportunity to review that report?
No, Judge.
Yes, Your Honor, yeah.
Any additions or corrections?
No complaints.
No, Your Honor.
All right, Ms. Reyes, I'm going to find that you previously entered your plea of guilty in each of these cases freely and voluntarily. And cause number 26 DCCR 0265, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation, and I'll go over some of those in just a minute. And cause number 26 DCCR 0787, find sufficient evidence to find you guilty. However, I'm also going to follow the agreement that you made and defer all proceedings and place you on probation for 10 years in that case. Same thing, you'll have a $1,000 fine and be required to follow all of the rules and conditions of probation. Actually, hold on, there's only a fine in 26 DCCR 0265. There's not one in 0787. And then in 26 DCCR 0788, also find sufficient evidence to find you guilty, but I'm going to follow the agreement and defer all proceedings and place you on probation for 10 years. You're ordered to follow all of the rules and conditions of probation in that case. Part of those rules and conditions are that you're going to be on the mental health initiative caseload, and that's to give you whatever help you need so that you can be successful. The important thing about that is if they say that you need counseling or medication or whatever it is, whether you feel like you need it or not, it's going to be ordered that you do it, okay, for your benefit. And if you do everything that you're supposed to while you're on this probation, this is a great, great opportunity for you. You don't have a felony conviction on your record. You'll be able to finish this without any issues, and the cases will be dismissed hopefully at the end if you are successful. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. In two of your cases, you could be revoked and sent to prison for 2 to 10 years. And in the other case, you could go to prison for 2 to up to 20 years. Do you understand?
Yes.
I will sign dismissals and all of the other pending cases as part of this agreement. I'm going to hand you, in these cases, the trial court certifications that shows that these are agreements that I followed, and so you've waived your right to appeal.
Yes.
Good luck to you, ma'am.
Thank you.
Brad Thomas Thibodeau.
Yes.
And will your client waive the formal reading of the indictment?
He does.
Mr. Thibodeau, in cause number 25 DCCR 0542, you're charged with the state jail felony offense of criminal mischief, impersonating a public service. Is it impersonating or impeding? Hold on. Impeding, sorry. Causing impairment or interruption of public communications. And that's from March 18th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I'm sorry. And I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney's office, you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. There would also be restitution in the amount of $1,848. Is that your understanding?
1,480.
84.
1,484.
Y'all wrote 1848. What's the amount?
All right. 1484.
Okay. $1,484. Is that your understanding?
Yes.
Speak up, please.
Yes, sir.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, sir.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Thibodeau is not competent?
No, Judge.
What is the state's position with regard to waiving pre-sentence?
We've agreed, Judge. He has a 1999 delivery of controlled substance. He received 10 deferred on that. I don't have any indication that he did not successfully complete it, unless he does. And in 2016, he had 20 days on a criminal trespass. With the restitution determined, I have an address for the Windstream Communication Company on Second Street in Winnie. It's directly there, so I don't have a problem if you don't waive.
All right, so I'm going to waive the pre-sentence report, Mr. Thibodeau, and find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 5 years. You're ordered to pay the fine of $500 as well as restitution in the amount of $1,484 and to follow all of the other rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation, if you successfully complete it, the case will be dismissed. You'll never have the felony conviction. The other side of that is if you violate any condition of probation, you could be brought back into court, found guilty of the offense, and sent to the state jail for anywhere in the range of punishment, which is between 6 months and up to 2 years. Do you understand? It's very important that that restitution get paid from the beginning. A lot of people think, well, I've got 5 years, I'll pay it later. I want you to make payments towards that restitution immediately. Even if it's a little bit every month, get it paid off, okay?
Yes, ma'am.
All right, thank you. Good luck to you, sir.
Yes.
That's the trial court certification. That shows that this was an agreement that I followed, so you waived your right to appeal. All right, good luck to you, sir. Morning, sir. Are you Hakeem Thomas?
Yes.
And this is 25 DCCR 0843. Mr. Thomas is charged with aggravated robbery. His case is set for trial to begin with jury selection next Monday. And what is the announcement?
Well, Judge, as far as the defense side, we're not ready to proceed at this time. There's some supplemental discovery I've been made aware of that we're looking to get copies of. I guess as soon as I'm able to get that, then I'll be able to assess it and go over with my client, and so we can prepare from there. But we're still
What's?
2 things, Judge, if I may.
Mhm.
I had a vacation letter in for next week that I submitted in December.
Oh, okay.
I think maybe this one just accidentally tagged along with.
Well,
posting it.
and sometimes what we'll do is leave it on a pretrial, and that way if something gets taken
Yes,
care of.
and it happened to be a good thing in this case, and Mr. Wilkerson's here, he represents the co-defendant. I've been working diligently with my investigators to try to get some rather large supplemental discovery from different agencies, not even in a county, DPS in Chambers County Sheriff's Office, video from there. They have sent all that. I received an email with a lot of that yesterday. There's also some things in Fort Bend with respect to older offenses. There's a continuous offense of Port Arthur that goes along with this. So I would prefer to try Mr. Wilkerson's client first. It is set on August 17th. I'll make sure both counsel has that discovery by this week, as soon as I get it all downloaded and get it to them in the appropriate format. But that's kind of where I am.
So everybody should have all of it this week.
Everything that's come in. Yes.
Okay. All right, so let's do this. I'm just going to reset Mr. Thomas a normal reset on the trial docket. That gives, since you're on vacation, gives you plenty of time. And then Mr. Wilkerson's, obviously we'll deal with that in about 3 or 4 weeks, which hopefully will give you plenty of time, Mr. Wilkerson, to go over everything, and we'll see where we are on that case. All right, you can go back with the bailiff, sir. Good morning. Are you Stacy Tyler?
Good morning, sir.
And will your client waive the formal reading of the indictment?
She does, sure.
Ms. Tyler, in cause number 26 DCCR 0800, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from March 30th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 15 years in prison, which means if we go forward, you'll be leaving your punishment up to me. I can sentence you to 15 years. I can give you less. It'll all depend on the information that's brought to me at a sentencing hearing. You have an absolute right to have a jury come in and decide 2 things. The first would be to decide if you're guilty or not. And then you could leave your punishment up to them if they found you guilty. If we go forward this way, you're waiving that. And is that what you want to do? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection.
It's admitted. Is there any evidence that Ms. Tyler is not competent?
No objection.
Right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get.
The judge has made her position clear. This is not an endless series of second chances. What makes this hearing so tense is that the defendant is standing at a critical point where one more mistake could completely change the outcome. The court is not simply looking at what happened today, it's looking at whether the defendant can be trusted to follow the rules going forward. And when the judge brings up the possibility of a 20-year consequence, the stakes suddenly become much bigger. This is the moment where a warning stops sounding like a warning and starts sounding like a final opportunity. Whatever happens next could determine whether this defendant walks away with another chance or faces a dramatically different future.